Hi, I'm Jason Sullivan of Rathbone Group, and this is on Subrogation. This video is going to focus on potential conflicts of interest that may arise for subrogation attorneys. Attorneys play an important role in the legal system, and it's very important that clients have trust and faith in their attorneys that they are representing them to the best of their ability. They're looking out for their own interests. They are holding a loyal relationship with the clients and doing everything they can for their client's own interest and not being persuaded or pulled away by other competing interests. For that reason, conflicts of interest are a big no-no when it comes to the practice of law. Most states have adopted some form of the rules of professional responsibility. In this video, we're just going to focus on the ABA rules. Although not identical to what's been adopted in each state, the fundamental core is there in that lawyers must not have conflicts of interest and must do everything they can to avoid those conflicts and putting themselves in a position where those conflicts of interest arise. So Rule 1.7 of the ABA rules states that a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. The rule defines concurrent conflict of interest as existing if the representation of one client will be directly adverse to another client, or there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client, a former client, or a third person, or by the personal interest of the lawyer. Now, if there is a concurrent conflict of interest, the rule does allow an attorney to still represent both parties under limited circumstances. And what the rule looks for is if the lawyer reasonably believes that they will be able to provide competent and diligent representation to each affected client, the representation is not prohibited by law, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal, and each affected client gives informed consent confirmed in writing. So let's look at some scenarios where a conflict of interest may arise. Let's say we have an attorney who does some subrogation work, but he also does maybe some criminal work, and maybe he represents some transactional clients. So he has a landlord that buys property, and that attorney does all the paperwork to do those property transactions and the purchasing or selling of the property and any contracts he has with third parties that maintain or manage the properties. The attorney does all of that for the landlord. The attorney then gets a subrogation case from one of his insurance clients, and that landlord had a car accident. He never told the attorney about it, but now there's a subrogation claim against that landlord for the car accident he caused. So the attorney represents both the insurance company on its claim against the landlord, and he also represents the landlord in other activities that the landlord carries out. So looking at the rule, can the attorney take on this representation? And we can see that the representation of the insurance client would be directly adverse to the landlord. So we do have a concurrent conflict of interest if the lawyer were to try to take on this case. The insurance company is trying to collect from the landlord, and the landlord is probably not going to want to pay the insurance company back. They're distinctly at odds with each other. And this is not a case that could be handled with written consent as permitted under the second part of the rule. And the reason for that is the insurance company's claim is directly adverse in a litigation case against the landlord. So it falls outside of what could be allowed to be permitted with a written informed consent. So in this type of scenario, you always have to check to see, is the defendant I'm pursuing on behalf of the insurance company also an existing client, even if it's in other matters? And if it is, you're going to have a concurrent conflict of interest and not be able to take that case. So now let's look at another example of where you may have a concurrent conflict of interest that would need to be addressed. You're a subrogation attorney, you receive a file from a client and you look at it. You don't defend or represent the defendant in any other matters. You do a lot of work for this insurance company. It looks like something you're all ready to go and proceed upon. And then maybe you get a call from the client or you get a call from the insured, and you find out that the insured also has some out-of-pocket losses from this collision. Maybe it's just a minor out-of-pocket loss that they had to pay for their rental vehicle. Or maybe it's a 6-figure personal injury claim that they need representation on. Everybody's going to pursue the same defendant, so do we have any issues with a concurrent conflict of interest? And looking at the rule, there's not necessarily on the face a direct adversity between the two clients. Both the insurance carrier and their insured want to collect money from the person that was responsible for the loss. They're not looking to get money from each other. Now, as an attorney, you would have to look and say, well, wait a minute, does the insured have a potential claim against the insurance company? Is there any possibility of a dispute over coverage? Maybe the insured should be claiming that that out-of-pocket should have been covered by his policy. Or maybe there's additional coverage that would be available, such as a UIM policy if there was that personal injury claim. If the insured is going to be turning around and making a claim back to the insurance company, that would be adversity, and you wouldn't want to take on that case, and you'd be barred from taking on that case because of that conflict of interest. But assuming none of those things exist, you still have some other concerns to think about. And looking at if you're representing two parties in a joint action against a defendant, what are some of the things you have to be cognizant of? Well, the first thing I always think about is who's going to pay for the litigation costs? There's filing fees, there's service fees, there may be deposition costs, potentially expert costs. If you have two clients and you're going to have costs towards the claim, which client is going to be responsible? And if not which client, how are those costs going to be divided? Another thing is the attorney fees. How are you as the attorney going to be paid as between these two clients? Is the insurance company agreeing to foot the entire bill and nothing's owed by the insured? Is the insurance company expecting that the insured also share in the cost and receive at the end of the case, if there's a recovery, a reduced amount if it's on a contingency fee? Those are the types of things that you're going to need to make sure that you have sorted out before you undertake representation of both parties. Also, settlement. Who has authority to decide to settle in the case? You may have a situation where there is an offer on the table and one party may say, yeah, we want to take it, and the other party says no. For instance, if the insurance company just has a property damage claim and they have an offer that they want to accept and they don't want to incur additional expert costs, accident reconstructionist, on the one side, you're going to have your insurance company say, yes, take that money. And then on the other side, you may have an insured who has a much larger claim. He wants to spend the money, say, let's continue to proceed, push, push, push. Now you have two clients on either side of you that are saying one thing and the other saying the other, and what do you do in that case? So that is an example of where suddenly now there is a conflict, even though your clients appear to have an aligned interest. Also, you may have questions on strategy. One client may want to proceed with depositions and incur that cost. The other client may want to do a motion for summary judgment. The other may not want to take the case to trial at all. One client may. You may have different opinions on the strategy, and you as the attorney, you have a duty of loyalty to both, and which client are you going to follow? You have to make sure that this has been addressed, and if there is a decision as to which client has the say in the case, and the other client may not agree with that, how are you going to resolve that conflict between the two? Finally, authorization of costs. And I've kind of mentioned there are the costs of the filing fees, but depositions, experts, all kinds of other costs can add up. And you may have one client with a vested interest and a willingness to spend that money and another client that may not, and they may want to end the litigation. So you may have differing opinions between your two clients on that. The caveat that allows an attorney to continue to handle that concurrent conflict of interest is if you have informed consent in writing from both clients. And this is particularly important. It has to be informed. So as an attorney, you have an obligation to tell each of the clients, here are the cases where I think we may have disagreements, and I'm going to owe a duty to each of you. And if you can't figure it out, or if we don't have an agreement before it starts in writing how we're going to handle the situation, then I'm going to have to withdraw from the case, and I'm not going to be able to represent either of you. And no client is going to want that. It's going to lead to extra expense, extra delay, and in terms of proceeding on the case, you're going to have two unhappy former clients as opposed to two clients you're able to handle this with. So as an attorney, you're going to want to identify all of these potential issues, put them in writing, explain them to each of your potential clients separately as to what it means, what outcomes could be, how it may arise, and how you would have to be handled. And then if they agree to say, no, that's okay, we're willing to proceed in this case, then you as an attorney would need to get that in writing from them. But of course, as an attorney, you may not want that to happen. You may not be willing to take on both cases. So even though you may have a client that says, can you please just help our insured out? Or you have an insured who's just pleading to have some assistance because they don't have an attorney for whatever reason, you have to make sure that you're carrying out your due diligence and following the rules of professional responsibility in informing your clients, confirming that you can actually continue to handle that case or begin to handle that case, and letting them know and getting that informed consent in writing from each of them before you proceed. For On Subrogation, I'm Jason Sullivan, and that's the long and short of it.